time set for hearing on motion.
In Your Honor, I think we wanted an adjourned date for continued work on the motion.
February 5th available at 1:30.
Please, Your Honor. Thank you.
Mr. Bloom, your attorney's going to supplement the motion and we'll hear back on the 5th.
This keeps cutting out. I couldn't hear you.
We're going to adjourn at the request of your attorney to supplement the motion that was filed with the court today.
So what date?
February 5th.
Yes, ma'am. Okay. I guess I can't put on record the things that my attorney told maybe was going to let me put on record, but that's okay. That's okay. I'll just go on being treated, subjected to cruel and unusual punishments, and my attorney won't even speak up for me. Thank you, Your Honor. Have a great day.
You too.
Thank you.
Number 19, People versus Michael Backer, 23-511 FH.
Alex Jablowski for the people.
Kenneth Overwater, Assistant Public Defender, on behalf of Mr. Fafard, who's present from Washington County Jail. Mr. Fafard, would you state your name for the record, please?
One more time, sir.
My name is Michael Fafard, Your Honor.
Wonderful. Okay. Yes, you have a lot of ink.
I have about 4 inch candles.
And I think we're probably going to be okay for that. Guidelines.
As to the guidelines, Judge, the crime category or crime class was listed as a person crime. It should be property.
I agree.
Which would then make OVs 7, 8, 11, 17, and 18 not scored. Fortunately for us today, they were scored at 0 anyways. But they would then be removed once the correct crime group is placed on the SIR. It's my understanding that Mr. Overwater is objecting to OV2.
That is correct, Your
Brigham?
Honor. Your Honor, in this case, I do not believe that the paper that Mr. Fafard used is an incendiary device as defined under the statute or in the guidelines. I do not believe it should be scored. I believe it should be scored as 0.
And Judge, I would just submit that the PSI and the other information shows that Mr. Fafard was using what appeared to be paper or paper towels or something of that nature as he jammed it into the gas port, the fill port for a gas tank on a car, and lit it on fire. It was still burning when the police arrived, or smoldering, and that he was using that as a device to try to light the rest of the car on fire.
Well, he certainly wasn't using it as a weapon, Your Honor, which is what the OV2 is meant to score for. This is property damage by fire, which is, I don't believe, what OV2 is meant.
Otherwise, it wouldn't be scored for a crime against property. So.
It can be, but I think it would be a property crime and weapon. This is not a weapon. Can't throw a burning
flame coming out of a car that's connected to gas.
No, ma'am. No, ma'am.
Mr. Fafard, thank you very much. I will do this. No, you don't need to say anything, Mr. Fafard. Thank you. Certainly wasn't used as a weapon in this case. Whether or not it could have been, it wasn't. If that were the case, then every single arson ever would always be scored OV2 for 15 points. And that's not the way that offense variable is designed to work.
I don't think that's true either.
Ma'am, nothing happened to the.
Mr. Fafard, this is not your time to speak.
Vehicle, ma'am. I'm just letting you know.
Mr. Fafard,
What happened to the vehicle?
thank you.
Thank you.
So, Mr. Prosecutor, you give me your facts, you can give me your position.
Oh, I think it should be scored.
Incendiary device under MCL 77732 parens 3 parens D includes gasoline or any other flammable substance.
Didn't actually light any gasoline, Judge. If he had done that, the car would have exploded. Gasoline is in the tank. The only thing that he lit was a piece of paper.
The wind blew it out, ma'am.
Mr. Fafard,
Piece of paper out.
Mr. Fafard, please don't say anything else.
Yes, sir. Yes, sir.
Thank you.
Thank you.
Mr. Prosecutor, in the 15 under 77732 1E, it's possessed or used, but there's no attempt. No response.
I'm just pulling it up, Judge, so I can make.
You don't know it by heart.
No. Judge, I'm submitting that the device that was used,
The device being the paper?
Yeah.
Okay.
it's like using, if I was to set a time delay, but use a candle as a time delay, that's a device to light something else on fire as it burns down and then catches the rest of whatever I have the candle put into. I had dealt with an arson case on that.
First off, it wasn't a candle, but sir.
Mr. Fafard, I'm gonna have you stop talking right now.
Judge, I would just note that the definition of incendiary device includes gasoline, any other flammable substance, blowtorch, firebomb, Molotov cocktail, other similar device. This is not a similar device. A piece of paper is not a similar device.
It's not a piece of paper, it's a piece of paper connected to a gas, a car with gasoline in it.
He didn't possess the car with gasoline.
He used it to his own purposes, didn't he? I would say that would be used. So if he possessed or used, I'm gonna score it. Okay, what else do we have?
That was the only objection I had to the scoring of the guidelines.
Anything else?
No.
Any change in the request for restitution?
No.
Any request for a no contact order or
We have no statement from the victim.
any request for a no contact order?
Yes, we would ask that there be no contact with the named victim. I don't think that I think it was a stranger situation, but
Mr. Curtis.
yes. Yeah, I asked the court, follow the Cobb's evaluation that we had.
Your Honor, I would ask for the same. I'd ask the court to sentence my client pursuant to the Cobb's evaluation that was given. He has a sentencing date in Wayne County, I believe, of January 24th. and the court had agreed to release him from the Washtenaw County Jail at the time of sentencing. He'd be transferred to Wayne County. He'll be there pending sentencing. I believe he'll be sentenced by Judge Thomas there. So whatever her sentence is, and then once he's released from custody there, I expect him to be transferred to Ohio, which is he has holds there. It is his intent to reside in Ohio upon his release. That is where he has by far the most resources to manage his mental health. He's connected with the ZEP Center there. He also, his only sister, really the only family he has, she's present, resides there in Toledo and will provide support for him. He does have an apartment there as well. I have been in contact with his sister, so I have independently verified that she's willing to provide support for Mr. Fafard. So I would ask the court to sentence him pursuant to the Cobb's evaluation the court gave, and to a term of probation with no additional upfront jail.
Ms. Gist, do you have the language for the interstate contact?
I do.
I'll ask if you can put that on the agenda. Mr. Fafard, now is the time you get to speak. Is there anything you'd like to say?
No, ma'am.
He had indicated to me prior to today's hearing that he did not wish to speak in allocution in light of the fact that he did plead no contest to this matter. I will, however, inform the court that in conversations I've had with Mr. Fafard, he has expressed relief that his actions did not cause further damage and certainly did not cause any harm to anyone. And he has expressed remorse for the damage that was caused to Mr. Curtis's vehicle. And he's very thankful that Mr. Curtis is not seeking restitution in this matter in light of the fact that Mr. Fafard is on a fixed income and is a very limited means.
All right, Mr. Fafard, you have been given some favor as to why maybe this could have been very differently. I've seen very same circumstances where somebody stuck a roll of paper towels mixed with a cleaning rag in a gas tank and used the car essentially to make a Molotov cocktail, and it ended up in the murder of a baby. This could have gone a lot differently. And the fact that you didn't cause substantial damage and no one got hurt is luck was with you, but I understand you do have other things that you need to handle in Wayne County in Ohio. It will be the sentence of the court as to count 2 and file 23-511 FH that you're put on a term of probation for 3 years. It is consecutive to your parole in the state of Ohio. Your crime victims assessment fee is $130. Your DNA testing is $60, and your state cost is $68. Based on the representations in the pre-sentence report and accountings from your attorney, I will be striking conditions 2 and 3 due to indigency and in your incarcerated state. A no contact order with James Curtis will be added. You're not to have any contact with him directly or indirectly through another person by email, text, smoke signals, doesn't matter, no contact. No use of alcohol or illegal drugs, no possession or use of controlled substances. Complete any outpatient or residential treatments for mental health as required by your agent. Let's see. Waive confidentiality to any treatment program and disclose to your field agent to any treatment providers that you're working with. Obey all court orders. No assaultive, abusive, threatening, or intimidating behavior. No contact with anyone known to have a felony record. No weapons of any kind. You must not own, use, possess, or have in your control any weapons. Comply with any written or verbal orders made by your field agent. Report to probation no later than 1 business day following your release from the Department of Corrections. Submit to a search of your property without the need for a warrant if your agent has reasonable cause to believe that you may be violating your probation. Find and maintain legitimate employment of 30 hours a week. And since it's your intention to reside in the state of Ohio, Ms. Gist, could you give us the language for that interstate contact?
Yes. Your 4 conditions. The first one is you must report to the probation department the next business day following sentencing by 9 a.m. You may report to the Washtenaw County Probation Office by mail or other electronic method Pending acceptance of your transfer, you must pay $200 for the application for interstate transfer in the form of a money order before the transfer process is initiated. And you may return to your state of residence once the interstate paperwork has been completed by probation.
Mr. Fafard, after you completed one half of your probation sentence on the motion of your attorney or the motion of the probation department, you can be discharged, and it will be up for review. Your attorney is going to give you a copy of your appellate rights. If you'd like to appeal today's sentence, you can do that. The most important thing to note is that 42 days from today's date, you must make a request in writing if you'd like counsel appointed to you. Do you have any questions?
No, ma'am.
Okay, I understand you have a couple of stops before you're actually out. So whenever you do get out, you need to contact the probation department and arrange for your transfer back to Ohio to be concurrent with your parole down there or consecutive to your parole down there. Okay?
Yes, ma'am.
All right. See you then.
Mr. Favard, if you don't know who to contact when you get out, you can always call my office. I'll help you.
No contact, sir.
All right.
Thank you.
Judge, I filed an order dismissing the counts to be dismissed as pursuant to the plea agreement.
Yes. Same.